Good evening, everyone. On behalf of LiveLaw Academy, I welcome each one of you to today's session. My name is Rohit, and today I am here to discuss with you the concept of default bail and Section 480, subsection 6 of BNSS. As the topic itself suggests, the topic is default bail versus Section 480, subsection 6 BNSS. The topic itself suggests that primarily the objective of today's session is to understand the differences. But we must begin with some basics. We need to cover some basics first, and let's do that. Let's start with the very basic thing, the meaning of the bail itself, the meaning of the word bail itself. So bail means release of a person who is arrested. The person can be accused or the person under some kind of suspicion. When the person is arrested and bail is granted, it simply means that the person has been released from the custody. Now, this release can be subject to condition, and it is contingent upon executing either a bail bond or a bond. Bail bond, as you must have already known this, bail bond means the undertaking for release, and it is with surety, whereas bond simply means it is a personal bond, and there is no requirement of surety. It is an undertaking for release without sureties. The objective of bail. For this, we need to refer to one particular decision from the Supreme Court. We make a reference to it. Sanjay Chandra versus CBI, AIR 2012 Supreme Court 830. In this particular case, the Supreme Court has held that the objective, the purpose of bail is not punitive. We must understand this. And it was also stated by Honorable Supreme Court that the purpose is not punitive, that the detention itself should be viewed as a form of punishment. And the detention should not be there until and unless it is completely necessary to ensure the presence of the accused at the trial. Otherwise, it is as good as a punishment, right? You see, the concept of bail is very important. This case is also highlighting the same, and it is simply not possible to discuss such an important topic in just one session comprehensively. We require multiple sessions for it, and it involves various subtopics like the classification of offenses, the meaning of custody, the concept of anticipatory bail, under what circumstances bail is granted in non-bailable offenses, the concept of transit bail, and cancellation of bail, among others. So it is simply not possible to deal each and everything in just one session. And that's why, as I highlighted in the very beginning, today's session is only about default bail and Section 480, subsection 6 of BNSS. So the first section that we need to refer for our purposes is Section 167 of CRPC, which has now become Section 167 CRPC, which has now become Section 187 of BNSS. The need for these provisions, 167 CRPC, 187 BNSS, the need becomes very clear when one reads Section 57 of CRPC, which has now become 58 of BNSS. These provisions, 57 and 58, 57 CRPC, 58 BNSS, these provisions clearly put limitation on the duration for which an accused can be kept in custody when he is arrested without warrant. It is clearly stated that the person arrested without warrant cannot be detained in custody beyond 24 hours. Now, this duration of 24 hours is exclusive of the time that is required to take the accused from the place of arrest to the magistrate's court. And when the police deems it necessary to have an extended custody for the purpose of investigation, if they require the custody of the person arrested beyond 24 hours, then the same cannot be done in the absence of a special order from a magistrate under section 167 CRPC, which I have told you it has become 187 of BNSS. The purpose behind this provision is to ensure that further detention is justified. It is not arbitrary. And for the same, we can refer to another decision again from the Supreme Court, that is Uday Mohan Lal Acharya, versus State of Maharashtra. Citation for the same is 2001, Volume 5 SCC, page number 453. 2001, Volume 5 SCC, page 453. In this case, the Supreme Court clearly held that 167 CRPC is complementary to Section 57. It is supplementary to Section 167 of 57 of CRPC. And it was also highlighted by the Supreme Court that the objective is just not only to figure out whether further detention is necessary or not. It is also to give an opportunity to the accused to make any representation if he wishes to make, right, in terms with respect to his custody. Now, with this brief background, we can now see what exactly is prescribed under section 187 BNSS. So let's see. Here, section 187, it is titled as Procedure when investigation cannot be completed in 24 hours, right? I've already told you that this provision is supplementary. It complements section 58 BNSS, which was 57 CRPC. Same was highlighted in Mohan Lal's case, right? We have just referred to it. So for 24 hours, there is no problem. The police can have custody in cases where the arrest is without warrant. But beyond 24 hours, we need a special procedure to be followed under 187. There has to be a special order from the magistrate. Otherwise, the continued detention, the extended detention will be illegal. So let's see what is provided here. Subsection 1. Whenever any person is arrested and detained in custody, and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 58. And there are grounds for believing that the accusation or information is well-founded. The officer in charge of the police station, it is his primary duty, right? Officer in charge of police station is primarily responsible for the investigation. Here also it is his primary duty to follow this procedure under 187, or the police officer making the investigation, right? The investigation can be given to other police officers under different circumstances by the officer in charge himself or some superior officer, right? So either the officer in charge or the person making the investigation in the case, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate copy of the entries in the diary hereinafter specified. Now this refers to case diary relating to the case, and shall at the same time forward the accused to magistrate, right? So for further detention, if further detention is required for investigation purposes, then the accused has to be taken to the magistrate, and also the relevant documents relating to the case, the entries made in the case diary, they are to be submitted to the nearest magistrate, and this is for the purpose of extending the initial detention of 24 beyond 24 hours. Initially, it can be for 24 hours, beyond 24 hours, right? Now, let's see subsection 2. It is very important. See, under CRPC, old section 167 CRPC, it was prescribed that when it is interpreted by the Supreme Court, right? It was prescribed under section 167 CRPC that the during the initial period of 15 days, right? Initial 15 days detention, the magistrate is empowered to grant either the police custody or the judicial custody. And once the period of 15 days, the initial 15 days has elapsed, then the magistrate can only order judicial custody and not police custody. This was clarified in the Supreme Court case, in the decision which was given in. You can make a note of it. CBI versus Anupam Kulkarni, AIR 1992. Supreme Court 1768. AIR 1992, Supreme Court 1768. So it was clarified that beyond 15 days, for initial 15 days, the custody can be either police custody or judicial custody. And beyond 15 days, the custody can only be judicial custody. Here, I believe there is a need to clarify the distinction between police custody and judicial custody. And simply put, police custody refers to a situation where the accused, where the person arrested is under the custody of the police. He is put in the lockup, and there is no need to obtain a special permission from the magistrate to interrogate him. Whereas, on the other hand, judicial custody refers to a situation where the accused is deemed to be in the custody of the court, and consequently, he is not put in the lockup. He is put in a jail, and there has to be a special permission from the magistrate to interact with him and to interrogate. The police cannot do so in the absence of special permission from the magistrate. So that is the distinction between the two. So initially, under 167, during first 15 days, the custody can be either police or judicial. Beyond 15 days, the custody can only be a judicial custody. Though this proposition was doubted in several other decisions of the Supreme Court, now we need not refer to them for today's purposes, because the same has been dealt with under 187 BNSS now. BNSS has enlarged these provisions to some extent. Now let's see what is done here. I'm reading subsection 2. The magistrate to whom an accused is forwarded under this section may, irrespective of whether he has jurisdiction or does not have jurisdiction in the case, it does not matter. The jurisdiction does not matter. After taking into consideration whether such person has not been released on bail, or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as the magistrate thinks fit. As the magistrate thinks fit. For a term, this is important, for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days. Here it is referring to police custody. For the purposes of 187 BNSS, now the police custody can be for 15 days, right? That thing is same. That the period of 15 days is retained under 187 BNSS. But what has been provided differently here? This period of 15 days, see, during the initial 40 days or 60 days, out of the detention period of 60 days or 90 days, as the case may be, provided in subsection 3. We will be referring to subsection 3 just after a few seconds. Don't worry about that. So in subsection 3, the period has been prescribed, maximum period has been prescribed 90 days and 60 days, depending on the nature of the offense. So within that period, in the first 60 days or 40 days, as the case may be, right, depending on the nature of the offense, the classification in subsection 3, it depends on that. So in first 40 days or 60 days, the police custody can be for maximum period of 15 days. It is what is intended by the legislature here. Now this 15 days can be fragmented and can be allocated to different parts within 40 days or 60 days. This is something which is different when we compare it with the position which was initially under 167 CRPC. So police custody can be for 15 days, but this period of 15 days can be fragmented now. Initially, as interpreted by Supreme Court on CBI versus Anupam Kulkarni, you cannot have police jurisdiction beyond first 15 days. Right now, you can have that, but the maximum period can be in total 15 days, though it can be fragmented in different parts, and different parts of police custody, total police custody can be assigned to different parts of 40 days and 60 days. Right? This is something different. Now we move on to subsection 3, which is actually very important for our purpose of understanding default bail. See, subsection 3, this used to be subsection 2 under 167 CRPC. Subsection 3 here says, the magistrate may authorize the detention of the accused beyond 15 days if he is so satisfied so and so, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding, now maximum total period has been prescribed here, total period exceeding 90 days, where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more. If the offense is, it falls under any of these categories, punishable with death, imprisonment for life, imprisonment for 10 years or more, then maximum period of detention is 90 days. Within these 90 days, in the first 60 days, there can be a police custody. With further embargo, that police custody can be for total 15 days. Similarly, in other cases, see clause 2 here, 60 days is prescribed as the maximum time period for detention. Right? Now, see 60 days, 90 days as the case may be, the accused shall be released on bail if he is prepared to and does furnish bail. And every person released on bail under this subsection shall be deemed to be released under Chapter 35 for the purpose of that chapter. So chapter 35 is a dedicated separate chapter on bails on bail. And here, what is important for our purposes today is, upon the expiry of maximum period of 90 days or 60 days, as the case may be, the accused gets a right, the person in custody, the person detained in custody gets a right to be released on bail. This is known as default bail. It is an absolute right of the person. If he was in custody throughout, the person has to be released on bail provided he is ready to furnish bail. Right? Now, the important aspect for us to understand is the purpose. What is the purpose behind it? What is the policy behind it? The policy seems to be, it is very clear, right? The policy is to have a speedy investigation and to prevent unnecessarily prolonged detentions at the stage of investigation. Right? It puts a check on the investigating authorities, their power, right? You cannot put any person behind the bars for a prolonged period of time and then do not continue with the investigation. Right? This will be a clear-cut violation of the fundamental rights recognized under Part 3 of our Constitution, particularly Article 21. We have also seen this, that bail, actually, they have close connection with Article 21, the liberty. Right? So once this period of 90 days or 60 days expired and there is no police report made in the case, the investigation is not complete, then the accused gets an absolute right to be released on bail with just one condition, that he must be prepared to furnish bail. If he is not prepared to furnish bail, then nothing can be done about it. If he is ready to furnish bail, then there is no room for discretion for the court. The court has to release such person on bail, and hence this is a manifestation of default bail. The right is accrued to the accused because there is a fault on the part of the investigating authority, that the charge sheet has not been filed within 90 days or 60 days, as the case may be. Now, this is an indefeasible right. I'm telling you that there is no room for any discretion here. The moment that the period expires, the right gets accrued to the person. This was recognized clearly in few of the decisions of the Supreme Court. You can make note of them. The first one is Hitendra Vishnu Thakur versus State of Maharashtra, 1994, Volume 4 SCC, page 602. It was stated by the Supreme Court that if investigation extends beyond 90 days or 60 days, whatever may be the case, then the accused gets an indefeasible right to be released on bail. The word indefeasible here clearly indicates that there is no other ground to be taken into consideration for the purpose of granting bail under this section, under this subsection, right? It is an absolute right. And this absolute right was talked about in two other very important decisions of the Supreme Court. These cases are also referred when we talk about the scope of Article 21 of our Constitution. The first one is Husainara Khatun versus State of Bihar, 1980, Volume 1 SCC 108. And the other one is Rakesh Kumar Paul versus State of Assam, 2017, Volume 15 SCC, page 67. Right? Here also, the non-discretionary nature of the provision was highlighted. It is the duty of the court, the concerned magistrate, to release the person on bail once the period expires. Right? This is to ensure that there has to be a speedy investigation. Now, let's move on to section 480 subsection 6. 480 subsection 6, the corresponding provision in CRPC was 437 subsection 6. 437 used to deal with the cases where bail can be granted in non-bailable offenses. Non-bailable offenses. Same is provided under, is dealt under section 480. Let's see. 480, when bail may be taken in case of non-bailable offense, right? Let's see subsection 6. Subsection 6. It is provided if in any case triable by a magistrate. So it is only applicable to the court of magistrate. The trial of a person accused of any non-bailable offense is not concluded within a period of 60 days. 60 days. And these 60 days are to be calculated from the first date fixed for taking evidence in the case. If it is not completed within 60 days, from the first date fixed for taking evidence, that is when the trial actually begins, right? Such person shall, if he is in custody during the whole of the said period, right, for this period of 60 days, if he was in custody, be released on bail to the satisfaction of the magistrate, unless for reasons to be recorded in writing, the magistrate otherwise directs. See, on the face of it, it appears that subsection 6 of section 480 is also a manifestation of a default bail, right? Especially when we see that here also the right is accrued because there is a default on the part, there is a fault on the part of the court that the trial was not completed within 60 days. Here the objective is to have a speedy trial, right? So it might appear that it is also a default bail and exactly same provision as we have just seen in 187 BNSS. But there is a difference between the two. The first and foremost difference is that 187 BNSS is applicable at the stage of investigation. We have seen the purpose was to have a speedy investigation, whereas 480 subsection 6, it is applicable at what stage? When one can figure out just by reading the provision, it is applicable at the stage of trial. The first difference is this, right? So here the objective is to have a speedy trial, whereas objective under section 187 BNSS was to have a speedy investigation, right? Clearly different objectives. Second difference is with respect to the scope. under 187, we saw that once the period of 60 or 90 days, the period expires, there is a right accrued to the person. No discretion left to the court. Here, we see that there is a discretion available to the magistrate. Refer to this phrase in the last, right? Unless for reasons to be recorded in writing, the magistrate otherwise directs, which means 480 subsection 6 gives discretion to the magistrate. This discretion was not at all available under 187 BNSS subsection 3. Right? Here, magistrate for reasons to be recorded in writing, right? For practical purposes, for having a fair trial, or there is any other kind of undesirability to release the person at this stage, right? The magistrate can otherwise direct, which means the magistrate has the discretion not to grant bail to the person despite the fact the period of 60 days has expired. The trial has not completed within the period of 60 days, right? For better understanding, we can divide subsection 6 in two parts. See, first part can be up to the be released on bail. That's it. Read it up to the phrase be released on bail. If in any case triable by a magistrate, the trial of a person accused of any non-bailable offence is not concluded within a period of 60 days from the first date fixed for taking evidence, such person shall, if he is in custody during the whole of the said period be released on bail, right? So this first part seems to, if we read just first part, right, it is clear that it will appear that it is it is akin to 187 BNSS, right? It will appear that there is no discretion. The person has to be released on bail. And had the legislature stopped at this first part, right, and there have been no second part to this subsection, we could have said that yes, the two provisions are comparable. 187 BNSS also does not talk about discretion, and if there had been no second part in subsection 6, here the way we have divided it, right, we could have also said the same thing for subsection 6 of section 480, that there is no discretion. The person has to be released on bail once the period of 60 days is expired, right? But there is a second part. So the discretion which seems to be there in the first part, that discretion, the indefeasible right which seems to be there in the first part, right? That indefeasible right is taken away in the second part by providing discretion to the magistrate, right? See, unless for reasons to be recorded in writing, the magistrate otherwise directs, which means there can be a case where the person cannot be released on bail after the expiry of 60 days. It is completely upon the satisfaction of the magistrate, but definitely this power has to be exercised with the application of judicial mind. There cannot be arbitrary exercise of power. That is a different thing, right? But the thing is, there is a discretion available here, which is not there in case of default bail under 187 BNSS, right? So this was the difference between the two. Now the question arises, what factors will weigh in with the magistrate while deciding the application of subsection 6? So when the period of 60 days is expired from the date fixed for, first date fixed for taking evidence, right? Once that period is expired, the accused can apply under subsection 6 of 480 that, see, I was in the custody for the whole period. The trial has not been concluded within 60 days. I get a right. I should be released on bail. Such an application can be made. But here, the other grounds can be considered by the magistrate. We have seen that. What will be those grounds? What will be those factors? What factors will weigh with the court for deciding, for the purpose of deciding such an application? Right? Will they be the same grounds which are to be considered under subsection 1 of this section? See, subsection 1 provides some grounds, right? Then there are judicial decisions around subsection 1, right? So are these the same factors which are again to be considered under subsection 6, or we need to go beyond those grounds, or what weightage is to be given to each of such grounds? Can there be an exhaustive list given for such factors? Right? All these questions, they will come up in your mind, right? And to answer these questions, we can refer to the recent decision given by the Supreme Court. It came on 18th February 2025, right? Sube Lal alias Sushil Sahu versus State of Chhattisgarh. 2025, LiveLaw, Supreme Court 223, right? Let's read important paragraphs to find answers to these questions. We can refer to paras 11 to 15 of the judgment. Now, the interesting part of this judgment is the same questions were there before Gujarat High Court when Justice Pardiwala was a judge there, and when this case come this before the Supreme Court, it was again Justice Pardiwala who was on the bench. This is an interesting fact, and his previous judgment in the Gujarat High Court case has been referred to in this case, and now very um, intelligently the factors have been discussed here. Let's refer to para 11 to 15. Para 11 to 15, though my advice is always to read the judgment in full, right? There has to be a complete reading of the judgment to understand the law better, right? But for today's purposes, we can cut it down only to 4 paragraphs. Sorry, 5, 11, 12, 13, 14, and 15. Let's see what is provided here. Para 11. The grounds relevant for the purpose of refusing bail would not be the same which could have weighed with the magisterial court while refusing bail under 437(1). Now they are referring to the provisions of CRPC 437(1) and 2. We have seen they are exactly, 487 is the corresponding provision, and it also provides grounds under subsection 1, subsection 2, right? So they are need not be taken into consideration when the magistrate decides an application under subsection 6. But in the very next paragraph, they provide, the honorable judges, they have provided, we may, however, hasten to add that cannot be an absolute proposition, and some of the reasons which may be relevant for rejecting regular bail under subsection 1 and subsection 2 may also be relevant for rejection of application under subsection 6, right? So there is no absolute proposition that is laid down by the Supreme Court, right? The factors can weigh in. The factors which the court normally takes into consideration for rejecting regular bail under subsection 1 and subsection 2, they can also become relevant here also, here under an application under subsection 6 of the provision, right? So they also said that we do not subscribe to the theory that factors which are relevant for rejecting regular bail at the initial stage are not at all relevant for rejecting application under subsection 6. So such grounds can also be relevant. They can also weigh with the court. Then it answers the question, can there be an exhaustive list provided to of the factors to be considered? See, here the court provides fact situations are so large in numbers that it may not be possible to contemplate, enumerate, illustrate, or incorporate the factors which would be relevant and which would not be relevant for the purpose of rejecting application under subsection 6. It is simply not possible. There can be endless circumstances, there can be endless factors, right? They have to be taken into consideration on case-to-case basis. There cannot be an exhaustive exhaustive list of factors, right? But certain grounds can definitely be provided for. See, then some of the grounds are listed. Para 13. In the view of the Supreme Court, following factors would be relevant, though not exhaustive. First, whether the reasons for being unable to conclude trial within 60 days from the first date are attributable to the accused. If the delay is attributable to the accused, then it is one of the established principles of legal systems across the world that a person cannot be allowed to take advantage of his own wrongs, right? The same thing will be applicable here as well. If the delay is attributable to the accused, then subsection 6 application has to be rejected. Then second, whether there are any chances of the accused tampering with the evidence or causing prejudice, right? Same kind of factors are weighed for rejecting a regular bail application under subsection 1, subsection 2. Then whether there are any chances of abscondence of the accused of being bailed out, right? This also weighs initially. Whether accused was not in custody during the whole of the said period, because under subsection 6, one of the requirements is for the whole period of 60 days, he was to be in custody. Then only subsection 6 application can be made by him, right? So this factor also needs to be taken into consideration. Then, if the answer to any one of the above referred fact situations or similar fact situations is in affirmative, then that would work as a fetter on the right of a right that accrues to the accused in the first part of subsection 6, right? So it will definitely be a limitation on the right that accrues in the first part of subsection 6. Then 14th we can skip for now. Then 15 goes on to add to these circumstances, to these factors, right? Some illustrative list is provided here. It would also be relevant to take into consideration the punishment prescribed for the offense for which the accused is being tried in comparison to the time that the trial is likely to take. So see, if the offense carries lesser punishment, but the prosecution wants to examine more than 100 witnesses, right? It will be a nightmare if the person remains in custody for the entire period, right? So this factor can be taken into consideration. Then regard being had to factors like volume of evidence, number of witnesses, also workload on the court, availability of prosecutor can also be taken into consideration, number of accused being tried with accused and their availability for trial, etc. All these factors can also be taken into consideration before accepting or rejecting an application under subsection 6 of section 437 CRPC, which is now subsection 6 of 480 BNSS, right? Right? So these all these questions that can come up when we read subsection 6 are addressed here. So to conclude today's session, the bail which is granted under 167 CRPC, which is now 187 BNSS, and bail which is granted under 437 subsection 6 CRPC, which is now 480 subsection 6 BNSS, they are different in scope, right? One is mandatory. There is an indefeasible right which accrues to the person in custody, whereas the other provides discretion to the magisterial court, right? Secondly, what factors are to be considered for the purpose of application under subsection 6? We have seen whether he was in detention, continuous detention for the said period prescribed by subsection 6, whether the fault, right, is can be of the accused, the trial is not completed within the period of 60 days as prescribed, right? Then other factors like abscondence, the chances of witness tampering, then workload of the court, etc. we have seen, right? You can again refer to these paragraphs. I have made you note down the relevant decision also. And in case you have any doubt, you can always reach us and I'll see you in more such sessions. And I'm again repeating myself that if you want sessions on any particular topic, subtopic, on any area of law, please inform us, interact with us in the comment section. And if you liked the video, please, if you are new here, subscribe and also share it with your peers. It can be helpful for them as well. And in case you want to check out the course that we offer, you can refer to the website for that. And there is a contact detail that is shared. You can contact the person, seek relevant details, make an inquiry. We are here to help you. And I'll see you in more such sessions. Till then, take good care of yourself and keep on reading, keep on revising. See you in the next one. Thank you.